Hi everyone, in this lesson we'll be talking about the Fair Labor Standards Act and the Family and Medical Leave Act. So, like I said, the Fair Labor Standards Act is one of the things we'll be talking about. It was passed in 1938. It prescribes a minimum wage, overtime, child labor regulations, record-keeping requirements. The Family and Medical Leave Act is United States' attempt at something like a maternity leave type of legislation, and it provides unpaid leave for medical reasons. So let's dive right into the FLSA. You could create an entire law practice based on either one of these acts, and they can get in the weeds very quickly and quite extensive. I tried to provide you a good outline of both to give you some general knowledge and get you sort of up to speed with the main points of them. And then if you want to dive deeper, I provided a lot of links in here to where you can go out and learn more. So, Fair Labor Standards Act, again passed in 1938, it established the minimum wage, overtime pay, record keeping, and child labor standards affecting full-time and part-time workers in the private sector and in federal, state, and local governments. We've all got some kind of awareness of the FLSA because we're kind of aware of what the minimum wage is, or at least that there is one. We're kind of familiar with the idea that if you work over a certain number of hours in a week and you're not salaried, then you're entitled to overtime pay. Kind of aware of the fact that young children shouldn't be working and stuff like that. So we have some general knowledge about it. So let's look at some specifics. So let's start with the minimum wage. The minimum wage has been set at $7.25 at the federal level since 2009. There's always, especially around election times, there's always some movement or some voices that are saying the minimum wage should be raised. Now, there are pros and cons to this. It's a lot more complicated than just one side or the other. The truth is usually kind of somewhere in the middle here, if we're taking a reasonable and rational approach. Now, the federal minimum wage isn't the end-all be-all because states and some municipalities can set a higher minimum wage. So each state can go in and set a minimum wage that would apply within the borders of that state. And in a lot of states, municipalities can even set higher minimum wages. You can't set them lower, or you can, but you couldn't pay lower because you'd still have to pay the federal minimum. The theme with a lot of state laws interacting with federal law is that states can generally pass laws that are more protective than the federal law, but they can't enforce laws that are less protective than federal laws. So we'll see that in multiple places throughout the course. Now, with that said, in 2023, the North Carolina General Assembly passed a law that prohibits local governments from enacting laws that modify state-level laws on wage levels, hours of labor, aka overtime, payment of earned wages, benefits, leave, and well-being of minors in the workplace, because the General Assembly is our version of Congress, right? So they wanted to have control over the entire state rather than having the city of Charlotte pass a higher minimum wage, or the city of Raleigh or the city of Gastonia setting a minimum wage that's different than the state level. And so they wanted to have all that control for themselves, setting the one statewide standard rather than a patchwork if municipalities decided to pass their own. You can agree or disagree with that and then vote accordingly. Let's spend just a minute and I'll kind of try to contextualize minimum wage for you just a little bit here. If I can get my links to work. Hold on. Okay, I've got it working now. Sorry, I accidentally closed the window I was trying to open here. Okay. So what this graph shows us is both the nominal and inflation adjusted, or the real wage. So we can see it started back in 1938. And what this tells us is that it was set at 25 cents an hour, which adjusted for today's dollars, or at least 2023's dollars, would have been about $5.34. So the blue line shows us incremental changes over the years as the minimum wage is adjusted up to try to keep up with inflation or whatever the goals are of Congress. And then the top bar kind of shows us when there's an adjustment over time, it will sort of move down as inflation takes its toll, and it moves back up as we adjust, and then it moves back down. So as far as real wages, the minimum wage would have topped out somewhere around 1970 at an inflation adjusted wage of about $12.61 in today's dollars, or 2023's dollars. And the last adjustment you see at the federal level here is, it shows it as 2010, but it was passed in 2009. The federal level set at $7.25, and which would have been equivalent of about $10 an hour today. And then since inflation has taken its toll over time, then that $7.25 value kind of goes down. But anyway, we can also see one other thing, if I can bring that back up. We can see a chart of each state's minimum wage. So there are some states here at the bottom, Georgia and Wyoming, who have their state level minimum wage set at $5.15, but really they have to pay the federal minimum of $7.25. Then there are a lot of states that are here with us in North Carolina where our law says it's $6 and something, or the federal, whichever is higher. So there's a lot of states that keep that federal minimum. And then as you scroll up, you can start to see states where they've passed a higher minimum wage, topping out the state of Washington at $16.28, and then the District of Columbia at $17 an hour. So you can see the variability of the minimum wage across states in the United States. I gave you, like I said, a lot of links here to the Department of Labor where you can learn much more about the FLSA minimum wage laws and things like that. There are sometimes exceptions and things like that. So we'll try to mention some of the major ones, but if you really want to get granular with it, you can just follow these links to learn much, much more. Like I said earlier, if the state or municipality minimum wage is less than federal, then the federal minimum wage will supersede that, and you have to pay at least the federal minimum. There is a large carve out for tipped employees. So if you've ever been a waiter, waitress, or worked in any other tipped position, you're probably aware that your employer can pay you a much lower minimum, set it right now at $2.13 an hour, as long as the understanding is that your tips are going to make up the difference and bring you at least to or above what the federal minimum wage would be. And if your tips don't bring you up to that level, then your employer is supposed to make up the difference. I can't think of a lot of examples where an employee has gone in and complained that they haven't made at least the minimum wage and then gotten their employer to pay that difference. But that is the way the law works, is that's what's supposed to happen. And we can, there is because a lot of people have questions. There's all sorts of scenarios you can consider. North Carolina does have a specific statute allowing for tip pooling for people who are waiting tables. Tip pooling would be, rather than everybody keeping the tips that they get individually, at the end of the night, you would pool all the tips that everybody got and then divide them amongst everybody, because some people get tipped more or less for various reasons. The law in North Carolina allows that, as long as you're not reducing anybody's actual individual tips by more than 15% under the tip pooling arrangement. Moving along, we're kind of familiar with the idea of overtime. If somebody's an hourly laborer and they're worked more than 40 hours in a week, as long as you're not an exempt employee, then you have to pay at least 1.5 times. So a lot of people just say time and a half for whatever their hourly wage would be for those hours over 40. Again, there was a lot of scenarios that can happen there, so I try to link you to resources so you can learn more about specific instances, but that's the general overtime guidance. For record keeping, employers have to keep records of employee time worked and the pay that they receive. They also have to employers have to display an official poster outlining the requirements of the FLSA. These are the posters that you sort of see usually not customer facing, usually back in a break room or back in an area where only employees would be. These posters for like OSHA or posters for the FLSA and, things that employers are supposed to keep posted so employees can sort of learn about their rights. As far as child labor, those regulations were designed to protect the educational opportunities of minors, prohibit their employment in jobs that would be dangerous or detrimental to their health or well-being. Here in Gaston County, even, we have a long history of these mill jobs, and you can probably talk to grandparents and hear stories about some of their family members who, back in the day, kids were being sent to the mills to work at, early teens and maybe even younger. And we sort of decided that maybe that's not a great idea and that kids should be focusing on their education when they're young and not working in very dangerous jobs. The FLSA is the result, we should say, of a large labor movement back in, the 30s that people fought for these rights. It's why we celebrate Labor Day each year and try to give the respect due there. The FLSA is administered by the U.S. Department of Labor and the Wage and Hour Divisions specifically. North Carolina also has its own Department of Labor and its own Wage and Hour Division. Linked you there to some websites where you can go learn, again, more. Sometimes students will ask about whether or not work breaks are mandated, either at the federal or state level. And I put that in here just because people often ask about it. But generally, the employer does not have to provide meal or rest breaks. There is an exception for younger employees. But for just general workers over the age of 18, then they don't have to. If the employer allows breaks, the employer has to pay for a break that would be less than 30 minutes long, but does not have to pay for breaks that would be 30 minutes or longer. So they don't necessarily have to pay for a lunch break or whatever if it's if it's more than 30 minutes long. Some types of jobs, there might be some dangerous types of jobs where there are mandatory breaks due to some other regulation outside of FLSA. So thinking about truck drivers, pilots, air traffic controllers, where there's a huge safety issue at play and we have to mandate breaks just to try to keep people safe. Now, if a state law gives a greater protection than FLSA, the state law will supersede. If the state law gives less protection, then the federal law will supersede. And that's the general pattern that we'll see in a lot of different laws throughout the course. Now, like I said, there are a lot of exemptions, exceptions to minimum wage laws. One of the biggest exemptions to minimum wage laws is what we call white-collar professionals. So executive, administrative, and professional employees, we abbreviate that to EAP. So you might hear about the EAP exception or exemption. So this includes a lot of people. So includes also teachers, academic administrative employees in elementary and secondary schools who are paid on a salary basis and outside salespeople. Okay, so getting a little bit more specific. This white collar exemption salary, and we're going to see a little bit of progression over time just to give you a visual and an idea of how this can change over time, and it depends on who's running the government at that time. So it had been set at $455 a week or $23,660 annually since 2004, but then in 2016, the Obama administration increased it up to $913 a week or $47,000 a year. But then that was struck down by the courts in 2017. Then it reverted back to the previous numbers. And then the Trump administration increased it up to, roughly $35,500 a year. Then you would be exempt. And there's an additional exemption in there for highly compensated employees. So the way that it works for the normal employees is if you're salaried, and you're earning at least this minimum, then you also have to show that you're involved in some type of executive, administrative, or professional work. Now, if you can't prove that, but you're highly compensated and you meet that bar for the highly compensated employee, then you're also exempt by default just because you're considered a highly compensated employee. Where does it stand now? Okay, so looking in 2024 when I'm creating this video, and we'll see this change again over time. So under the Biden administration, it's been increased to $43,888 a year, which is effective July of 2024, or $132,964 for highly compensated employees. And then they did something a little bit different this time. They built in this adjustment. Okay, so in January of 2025, it adjusts up to $58,656 a year. And then it's supposed to also change every 3 years going forward to try to keep up with inflation. At least that's the idea. So they try to set this rule that would make it automatically adjust every 3 years. Now, of course, this could all go away if a new administration comes in and says, no, we don't like that. We're going to change it to something else. Hi, everybody. Jeremy from the future chiming in again here to give an update. This is year 2025. But in November of 2024, that Biden administration rule about the white collar exemption here was struck down by the federal court, the same federal court in Texas that's been striking a bunch of stuff down from the Biden administration. So what we're doing is reverting back to the 2019 rule under the Trump administration. So this 2019 rule that they passed, the first Trump administration passed, is the rule that we're enforcing now. Again, things can change in the future. It's kind of annoying to have to keep making these updates because everybody keeps changing their mind what this exemption should be. But this is the world we live in, the political environment that we live in. Somebody wins an election, they change a bunch of rules. Somebody else wins and they change the rules again. So the lesson you have to carry forward is that if you're going to be an employer or a manager, or whatever it is, you have to keep up with all these changes as they're happening to make sure you're not violating federal law. So, like I said, you have to qualify for this EAP exemption. Generally must meet these 3 tests. One is I have to be paid a salary, meaning I'm paid a predetermined or fixed amount that is not subject to reduction because of variations in either the quality or the quantity of work performed. I have to be paid at least a specified weekly salary level and primarily perform executive, administrative, or professional duties as provided in the Department of Labor's regulations. And I linked you to that because you can go read a whole lot more about what exactly would qualify as executive, administrative, or professional if you have questions about that. So like I said, it can get in the weeds super fast. And so as an employer, because a lot of us are going to go out there and be either business owners or business managers, we have to make sure that we're doing things correctly so that we don't get in trouble later on. There's another exemption built in there for computer professionals who are paid at least $27.63 an hour. we might see that number adjust up and down as well over time. That's what it's at right now. Also exempt are employees of certain individually owned and operated small retail or service establishments not part of a covered enterprise. And what that would actually mean is they're not somehow involved in interstate commerce, so that they couldn't be covered under the United States Commerce Clause, which gives the federal government the ability to regulate business, gives them the authority to pass the FLSA and a lot of other laws. Now, that's not going to be a very widely used exemption there, so I wouldn't count on that. Another one is certain seasonal amusement or recreation establishments. I give you a link there so you can find out what exactly that means, but we're thinking about amusement parks, some summer camps. I know I worked at a summer camp when I was trying to pay my way through college. And for the summer, I was paid a very low salary, but they also provided room and board. So it got a little bit fuzzy there, but it was allowed under this specific exemption. Also covers messengers, full-time students, employees of certain small newspapers, employees of fishing operations, sailors employed on foreign vessels. It gets messy really quick because when the federal government's considering passing something like a minimum wage, a lot of companies are going to come in and have something to say about it. And if you have enough money to get enough lobbyists to carve out an exception for your business, then here you go. We have all these exemptions here. Also exempted are certain farm workers. Again, you'd have to learn more. Casual babysitters, certain people employed as companions to the elderly. Unpaid internships are allowed under certain conditions. And it all just kind of depends. So the general rule is that there's this minimum wage, but there are these very large exemptions here. So you just have to understand what kind of job are you either offering or are you working in to understand whether or not you're being paid legally. Okay. Let's move on to child labor laws, much shorter section here. The long and short of it is that most children can't work before the age of 16. Some children between the ages of 14 and 16 can work certain jobs that don't interfere with the health, their education, or their well-being. There will be restrictions on the times they're able to work, the kind of jobs they're able to work. Certain agricultural work is permitted. A lot of retail positions, some young people might be able to work as long as they're not handling alcohol, things like that. The minimum age for hazardous jobs is 18. Youth who are under 18, there is an exemption here for young people working for their parents. Okay, so if you're working for a family business, your family can get you working as early as they want, and there's an exemption there as long as the job isn't hazardous or serving alcohol for on-site consumption. And then I gave you a link there to learn more about North Carolina's specific youth employment laws, but it's basically the same thing as the federal that I gave you there. We mentioned retaliation briefly here because part of the FLSA is a section that prohibits employers from retaliating against an employee for exercising their right under the act. So if they file a complaint with the Department of Labor saying you're not paying the minimum wage like you should be, and then you get mad at them for that and then fire them, that would be retaliation, and they might be able to sue you for that. So just be aware of that. Now we'll move on. Like I said, there's a lot more to the FLSA than just that. Those are the basics. And I try to provide you those links so you can learn a lot more for those people who are going to be starting a business or who are going to be working in HR and all that stuff. So you can get a lot into the nitty gritty there. For now, for this class, we'll move on to FMLA, the Family and Medical Leave Act. Like I said at the beginning, this is the United States' attempt at creating a maternity leave law, but they expanded it beyond just maternity leave. And we'll look at what exactly that means. Again, I link you to some resources you can learn more, either from an employer side or an employee side, so you can understand your rights as an employee and your responsibilities as an employer. What does this provide? It provides up to 12 weeks of, keyword here, unpaid leave in a 12-month period for, and then it specifies some reasons that you can take this leave. So for instance, the birth of a child, to care for the newborn child within 1 year of birth, the placement with the employee of a child for adoption or foster care. So if you're adopting or doing foster care for a newly placed child within 1 year of placement, to care for the employee's spouse, child, or parent who has a serious health condition, to take care of your own serious health condition that makes the employee unable to perform the essential functions of your job, any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty. Okay, so that covers a lot. It covers me getting sick and being unable to do my job for a limited period of time. It covers one of my immediate family members getting sick. It covers the birth of a child or placement of adopted or foster child, and caring for somebody who's under covered active duty in the military. Okay, so we don't have paid leave. Most of developed countries have paid leave. We don't. Your company might, though. Your company doesn't have to, but a lot of companies provide paid maternity leave or other leave, sick leave, things like that. These are things that they don't have to do, but they offer because they're trying to recruit a highly qualified workforce. And if they see other companies are offering it and they aren't, then they will, but they don't have to according to federal law. Okay, so if you're fortunate enough to work for a company that provides paid leave, great. It also provides 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin. So some special considerations being given here to members of our armed forces. Who does this apply to? Okay, it doesn't apply to every company. So who specifically will it apply to? It applies to private sector employers who have 50 or more employees for 20 or more work weeks in the current year or the previous calendar year. Government workers are generally covered regardless of the number of employees. So the FMLA covers pretty much all government workers. And if you're a private sector employer, it only applies if the company has 50 or more employees for 20 or more work weeks in either this year or the previous calendar year. There are some companies who that the number of workers they have kind of fluctuates up and down and sort of kind of right on that line. So then you have to start looking at, well, for how many work weeks during the year did you have 50 or more employees? Okay. So who's an eligible employee? So an eligible employee is one who works for a covered employer. Okay, so what we just talked about. Has worked for the employer for at least, here's a key one right here, for at least 12 months. So in order to be covered under FMLA, you have to have been working for your employer for at least a year. Has at least 1,250 hours of service for the employee during that 12-month period. And I work at a location where the employer employs at least 50 employees within 75 miles of that work site as of the date when the employee gives notice of the need for leave. Why this 50 employee requirement? Because a lot of companies, when the government was considering this legislation, were saying, you know, we're a small company. We can't just absorb the costs associated with giving somebody this much leave and then guaranteeing that we'll take them back at the end of it. It would be an undue burden on us. So then they set this requirement. So a company of 50 employees or more hopefully will have the bandwidth to be able to absorb that person taking leave for that period of time without it unfairly affecting their business, or at least that's the idea behind it. You can agree or disagree with that, but that's the way the law works. Okay, so looking a little bit more at the FMLA here, the employee must give a 30-day notice where that's practical. Where it's not always going to be practical because health issues aren't always foreseeable and they don't always give us 30 days notice when they're going to pop up. But when it's reasonable, so if I'm having a child, then it is fairly easy for me to give at least, get at least some idea of when the child's going to be born. So then if that's the case, then giving 30 days notice that I'll be requiring leave seems pretty reasonable. If that leave is unforeseeable, then I have to give notice as soon as possible and as soon as practical for me to give that notice. Now, as far as giving notice to my employer that I'll need leave, I can do that orally, just by telling them. I can give it in written form. Either way would be covered under the law here. Now, once I give notice to the employer, that triggers an obligation for the employer. So they have to then provide notice of eligibility. They have to look into it and see if I'm going to be eligible for FMLA leave. And they have to give notice within 5 days of the employee request or of learning that an employee's leave might be for a qualifying FMLA reason. The employee might not even know what FMLA is. And they just say, hey, I'm sick, I can't make it. And then looking into it, I say this leave might actually qualify for FMLA. So that's that 5 business days for me to respond, giving them notice that they either are or are not eligible for FMLA leave. The employer can also require, if I offer things, paid time off, PTO, that can be for vacation or sick leave or whatever else it might be, the employee can require that you use up that leave first. But then I have to compensate accordingly if that leave is paid. Okay, so I can require that you use up all your sick leave before you take the unpaid leave, or use up all your vacation time before you take that unpaid leave. But I do have to pay it out if I normally pay it out. Let's say that I employ both members of a couple, so 2 spouses, and they're both requesting leave. I can restrict their leave to 12 weeks total for the couple in a 12-month period. The idea being that, well, losing one employee for 12 weeks in a year is one thing, but losing both, maybe that crosses the line over into undue burden. Again, this is the federal minimum here. And then companies oftentimes, like I said, provide their own version of leave that can be more protective than what the federal minimum is. Next point, the employer must continue to provide health coverage. This is the protection you get under FMLA. Now it's unpaid, so it might be the situation that you're not actually getting paid your salary or whatever during that period of time. So why does it matter? Because the employer, if they offer health coverage, they have to continue to provide that health coverage, and they have to restore the employee to either their same job or an equivalent job after the leave. So that's the protection there, is I get that leave and I get my job back at either the same level or an equivalent level, and I get to maintain my healthcare coverage during that leave period. Now, there's an exception to that. An employer may deny restoration to the highest paid 10% of their employees if it is necessary. I'd have to be able to demonstrate that it's necessary to prevent substantial and grievous economic injury to its operations. The idea there being that the highest 10% paid employees are probably performing much more mission critical duties and operations and decision making. So losing one of them might mean much more to a company than just missing a low level laborer. Okay. The company can require confirmation, medical confirmation of an illness, just to make sure somebody's not just pretending to be sick or pretending to be taking care of a sick family member or whatever. And there'll be a process involved in that. In 1997, There was an amendment passed that provided 24 hours per year for certain family obligations like parent-teacher conferences, taking a child to the doctor, finding child care, caring for elderly relatives. The last point in there is a point that people make a lot. So I'm letting you know what's going on just because we hear that all the time in the news. People often say the U.S. is the only industrially similar nation to not provide paid parental leave at the federal level. Like, again, a lot of private companies do offer paid leave, but federally it's not mandated. So some people think that maybe we should at the federal level offer paid paternity or maternity or family illness leave or whatever it might be. I don't see anybody making it a huge priority right now. Now that can change as elections happen, as political parties reprioritize and reemphasize certain things. It doesn't seem to be a huge emphasis right now in 2024 anyway. But over time that can change. A lot of this stuff can change. All of our laws can change as administrations change, and if they're able to garner enough support to pass a different law or amend a law or repeal a law. And that's just the nature of working in our society. But that's enough for now, and I hope you all have a great day.